How much pressure can a corporate officer and director put on shareholders to approve actions that benefit the officer and director? A Delaware chancellor considered the question of coercion in Lacos Land Company versus Arden Group Incorporated. Lacos Land Company owned 4.5% of Arden Group's Class A common stock. Bernard Briskin, Arden's chief executive officer and member of its board, owned 16.9% of Arden's Class A stock. That percentage rose to 21.1% if Briskin were to exercise his stock options. Therefore, Briskin was Arden's principal shareholder. Briskin had become Arden's CEO 10 years earlier when the company was struggling and its shares were worth between $1 and $2. Briskin had managed the company effectively, and its shares now traded for around $25. Briskin proposed amending Arden's certificate of incorporation to allow for Class B stock. Class A shareholders would continue to cast one vote for every share. Class B shareholders would be entitled to 10 votes per share. Class A shareholders would elect 1/4 of the directors, and Class B shareholders would elect 3/4 of the directors. But Class B shareholders would receive limited dividends and be subject to significant transfer limitations. All Class A shareholders could convert their shares to Class B stock. The conversion of all Briskin's shares to Class B shares would give Briskin 67% of the shareholder vote, but the reduced dividend and transfer restrictions made the conversion unattractive to most other shareholders. This proposal wasn't a response to any specific takeover threat. Instead, Briskin wanted to secure his position as CEO, even in the face of a future hostile takeover. Briskin threatened that if his proposed amendment wasn't approved, he might block future transactions that could be in the company's best interest but would dilute his ownership interest. The board, therefore, issued a proxy statement recommending the plan to Arden's shareholders. 64% of Arden's shares then voted for the proposal. Lacos sued Arden and Briskin in Delaware Chancery Court and then sought a preliminary injunction prohibiting Arden from issuing the Class B stock.